So we have seen there are many conflicts arised between fundamental rights and directive principles of state policy. There are many cases in Supreme Court regarding this issue. What if there is any clash between directive principles and fundamental rights? We say, Dr. B.R. Ambedkar said that fundamental rights and directive principles are novel features of the Constitution. So the government should not make any difference between fundamental rights and directive principles of state policy, because they together form a novel feature, and in every policy of the government there should be a reflection of both fundamental rights and directive principles. So we consider that fundamental rights and directive principles of state policy are not contradictory to each other. Rather, they are complementary to each other. They are supplementary to each other. They are subsidiary to each other. So both fundamental rights and directive principles, they shall go hand in hand. They shall go hand in hand. Then only there will be a sense of equality, or many ideals of the preamble would become reality. So in times of conflict between fundamental rights and DPSP, in general case, fundamental rights would prevail. Reason being, fundamental rights have given enforceability, that is, they are justiciable in nature. If there is a violation of fundamental rights, that particular citizen could move court. That is not in the case of DPSP. DPSP are not justiciable. They cannot be enforced. There are many reasons for not making DPSP justiciable, because India does not have that much of resources, because of diverse country. We have lot of diversity, multi-religious countries. We cannot enforce all these directive principles of state policy. But gradually we are trying to bring certain provisions in DPSP into fundamental rights. For example, by 86th Constitutional Amendment Act, we have made right to education. Earlier it was under Article 45 of DPSP. Now it has brought into fundamental rights under Article 21A, because the state knows, or a common understanding is, without proper education, without skill development, the country will not progress. That is the reason why we are providing free and compulsory education to the children. Gradually, we may also bring certain provisions from directive principles of state policy into fundamental rights. But as of now, if there is a clash between fundamental rights and DPSP, obviously the fundamental rights would prevail. That doesn't mean that DPSP are inferior. Both fundamental rights and directive principles of state policy they have equal importance. The state should give them equal importance while formulating any policy or by bringing any law. So what if there is a conflict? There are many cases in the court. In Champakam Durai Rajan versus State of Madras, the Supreme Court has reiterated that whenever there is a clash between FR and DPSP, the fundamental rights would prevail. As I said, because they are enforceable in the court, they are justiciable, that is the reason fundamental rights would prevail in times of clash between fundamental rights and directive principles. This was the judgment given in Champakam Durai Rajan case. Even in Golaknath case, there was the judgment by the Supreme Court that both fundamental rights and DPSP should be given equal significance by the state. But obviously, because we have fundamental rights, we have Article 32, which gives the power of enforceability. So we have right to constitutional remedies under Article 32, and under Article 226, this is the power to issue writs by Supreme Court and power to issue writs by High Court. So fundamental rights are enforceable. But for any state action, both fundamental rights and DPSPs should reflect, because DPSP, as we say, they are instrument of instructions. They instruct the state government in framing the policy. DPSP are more concerned with a community or society, whereas fundamental rights are concerned with individual person. So whatever welfare scheme the state brings are influenced by the provisions which are mentioned in Directive Principles of State Policy. We say fundamental rights are restriction in nature. Fundamental rights restrict the state in bringing certain law which takes away the fundamental rights of a citizen. But Directive Principles of State Policy will guide the state. They are more positive in nature. DPSP will guide the state in bringing such laws which affects all sections of the people positively, to establish a socialistic society, to establish a welfaristic society. The state need to follow the provisions mentioned in the Directive Principles of State Policy. So we have Golaknath case, where generally we have a dispute regarding property. Here in this case, the parliament, there was a clash between parliament and Supreme Court. Obviously, the Supreme Court says that the parliament under Article 368 cannot amend fundamental rights. That is, Article 368 gives only the procedure of amendment. What is the procedure followed in amending the constitution? But Article 368 does not give power to modify or take away the fundamental rights or to amend the fundamental rights. This was the judgment made in Golaknath case by Supreme Court. But later in Keshavanand Bharati case, the judgment was reversed. The Supreme Court said that the parliament has the power to amend fundamental rights, to amend the constitution, but it should follow the concept of basic structure. This we will discuss in Keshavanand Bharati case. So in Golaknath case, there was a clear judgment that parliament do not have power to amend fundamental rights. Later in Keshavanand Bharati case, that judgment was reversed. The Supreme Court overruled its case or judgment in Golaknath case and said that Parliament can amend any part of the constitution, including fundamental rights. But it says that there is a basic structure. There is a basic structure which shall not be violated by the Parliament. The basic structure should not be touched when there is a process of amendment. In again, after Keshavanand Bharati case, in Minerva Mills case, the Supreme Court has defined basic structure. It has reiterated again that yes, Parliament has the power to amend any part of the constitution, but without disturbing the basic structure. Here when we say basic structure, it is generally like in preamble we have mentioned India is sovereign, socialist, secular, republic, democratic state. So obviously this is a basic structure. The Parliament cannot amend the word secularism, though they have added secularism by Constitutional Amendment Act, but the basic structure like federation, it cannot modify a basic structure. So it was clear in the verdict given in Keshavanand Bharati case that Parliament has the power. Parliament can amend according to Article 368. By the power of 368, Parliament can amend any part of the constitution, but basic structure should not be disturbed. That is how in for amendment we have repealed Article 31, which was right to property. Right to property was mentioned in fundamental rights, that we have repealed because we have to bring many agrarian reforms to eliminate zamindari systems, raitwari systems, and we have provided this in legal right, which has we have made just a legal right. This is not enforceable in the court. So that was a decision in Keshavanand Bharati case. As I said, in Minerva Mills case, the same judgment was reiterated. The Supreme Court said that though the Parliament can amend any part of the constitution but should not disturb basic structure, and basic structure was defined by Supreme Court in Minerva Mills case. As of now, it is a clear-cut picture that Parliament as a sovereign authority, as a ultimate authority in framing law, in bringing any policy, but it should keep in mind that there should be a thing like basic structure which should not be disturbed. So by judicial review of the court will generally look that the constitution is not violated by any policy by the state. So where we have implemented this directive principles of state policy, we have many legislations, many laws related to this. So we have generally implemented in land reforms. As we said, the basic objective behind repealing of right to property is land reforms. So land reforms is, earlier in zamindari system, a single person used to have hundreds of acres of land. But the policy of the government, as we need to establish a socialistic pattern of society, the state should distribute the land to the poor, to the underprivileged section of the people. So we have brought land reforms. So this has brought many policies like abolition of intermediaries like zamindars, jagirdars and inamdars. We have brought many laws which affects the tenancy reforms. Tenancy are the people who work on land which generally they do not have. They are tenants. So we have given security to those tenants who work on the land, agricultural land. We also have brought many policies which distributes the surplus land to the needy people. So what we say is the provisions mentioned in the directive principles of state policy has directed the state, has guided the state in bringing several law or bringing several policies which affects the livelihood of the citizen. So we also say that we have 73rd Constitutional Amendment Act. This is again under Article 40 of Gandhian principles, that says that to organize panchayat systems, to strengthen the administration at grassroots level, to prevail democracy and governance at grassroots level. And hence we have, by this act, 73rd Constitutional Amendment Act, we have created a new part, that is part 9, panchayats. Now we have 3-tier body in panchayat, that is Gram Sabha, Mandal Parishad and Zilla Parishad. There shall be a periodic election for that every 5 years. There is a system of reservation also. Because to strengthen the lives of the people at rural area, we have brought this Constitutional Amendment Act and made panchayats a constitutional body. So 3-tier Panchayati Raj systems. We need also study Article 74th Constitutional Amendment Act, which talks about urban local bodies. Panchayats are rural local bodies, RLBs. So this, as we have mentioned in Article 40, this was under DS, Directive Principles of State Policy, DPSP. So we have given a constitutional status. So gradually we need to know that whatever provisions are mentioned in the DPSP will guide the state in framing such policies to establish an egalitarian society, to make sure that the wealth is distributed among all sections of the people, to prohibit the concentration of the wealth in the hands of few, to develop all the sections of the society, and also to improve all the things like we have primary sector, we have secondary sector, we have tertiary sector. So the government should take steps to give equal importance to all the sectors so that the growth is balanced, the development is comprehensive. We have cottage industries. This we study in Gandhian principles. So we have many government brought policies which improves village industries. Khadi and Village Industry Commission is there, which was established by the Act of the Parliament. We have Handicraft Board, Silk Board, Coir Board. This type of cottage industry will strengthen the people economically at grassroots level, that is at village level or at lower tier level. We have many programs which emphasizes, which strengthens the economic and social development of the citizen. In terms of education, as we have already discussed, we have this Article 45 is under DPSP. We have brought this under fundamental rights by amending Article 21A or by inserting Article 21A. We have brought right to education. This is Right to Education Act 2009, which makes compulsory the child should be in schools under the age of 6 to 14 years of age. So rural area development programs, these are important. These are also influenced by the provisions under DPSP. So we have programs like CDP, Community Development Program. We have IRDP, Integrated Rural Development Program. We have MG Narega. This is Mahatma Gandhi National Rural Employment Guarantee Act, which provides work, compulsory work to the people. So all these programs of the government will enhance the economic status of the people. The government is responsible to provide jobs to their citizens. That also decreases the level of unemployment. And we could ensure that the development is reached to all sections of the people. So this acts of the state government or central government will provide the decent standard of living. This increases the standard of living of the people. This is again in terms of health. There are many policies of the government which focus on the health of the people by establishing primary health centers, by creating government hospitals, by giving medicines available to the needy people, affordable treatment. So we have schemes like Pradhan Mantri Gram Swasthya Yojana. We have National Rural Health Mission. So these are very important flagship programs by central government which enhances the health of the people. So all these things are mentioned in the DPSP, and the government or the state will get influenced by the provisions of the DPSP and ensure that those provisions are implemented through such policies, be it health policy, education policy, manufacturing policy, defense policy, or any such policies. The state is influenced by the provisions mentioned in the DPSP. Though we say that directive principles are not enforceable, that does not mean the state will neglect the provisions of DPSP. The state has to consider the provisions of DPSP very seriously so that we achieve the concept of welfareistic state. No political party will ignore before the elections to insert many of the provisions of DPSP in their manifesto, because people will vote a party depending upon how much importance they are giving for welfareistic programs. You take any schemes like pensions to the old age people, scholarship to the students, pensions to the disabled people, or help public assistance or financial assistance to unemployment, or giving bank loans to the needy people. So all these policies, free drinking water, free electricity, insurance for crops, minimum support price, so all these policies are welfareistic in nature. So the citizen will make sure that before voting any political party, all these things have to be included in their manifesto. On the basis of their manifesto only, they would come to power. So all the political parties will ensure that the DPSP is given priority. So when we talk about environment, there are many laws which have brought by the state, like the Wildlife Protection Act, which ensures that the wildlife are protected, conserved and preserved, because we have many international conventions here. The Forest Conservation Act, the Environment Protection Act. On these lines only, we have developed many things, like we have conserved in terms of wildlife sanctuaries. We have placed many tiger reserves, bird sanctuaries, zoological parks. So all this makes it mandatory now, because we have a law. And any against this law will be punished. So poaching is prohibited. It's a criminal offense. Cutting trees in protected areas are prohibited. The environment should be protected. You cannot just go and build an industry there. You cannot set up a manufacturing industry which, by the pollution of such industries, the environment is disturbed. We have Green Tribunal, which will generally gives permission to establish such manufacturing industries. So many laws are there which have influenced by provisions of DPSP. In terms of heritage preservation, we also say that the ancient and historical monuments need to be protected. So we have Archaeological Sites and Remains Act of 1958. This is important, where the historical monuments are preserved and protected because they have a national importance. So this was a class on directive principles of state policy. One thing is, DPSPs are very much important. They are equally important as fundamental rights. No government or no state will generally disrespect the provisions of DPSP. So all those policies got influenced by DPSP to establish a welfareistic society, to establish a society based on socialism concept, on the concept of Fabian socialism, to provide basic amenities, basic necessities for the people who live in below poverty line or who are underprivileged. So to have an equitable balance or equilibrium in development, the state should take certain steps, proactive steps, to implement the provisions mentioned in Directive Principles of State Policy. With this, we finish the concept of DPSP. Thank you for watching my video.